All righty. Well, good afternoon, everyone, and thank you for joining us today for the Sudden Cardiac Arrest Foundation's webinar on Good Samaritan Laws. And I'm Gina Petty. I'm the Executive Director of the Sudden Cardiac Arrest Foundation. For those who may be new to the foundation, our vision is to eliminate preventable death and disability from sudden cardiac arrest and support people affected by sudden cardiac arrest. And our mission is to raise public awareness of sudden cardiac arrest and through initiatives that help save lives through education, research, and community. We are a national nonprofit organization and very glad to have you all joining us today. Um, Today, we are very happy to be joined by our presenter, Stephen Tannenbaum. Steve is senior partner in Tannenbaum, Bellantone, and Silver PC, a civil litigation law firm in Lake Success, New York. He is a graduate of Brooklyn College and New York Law School and has been recognized as a top attorney in North America. Mr. Tannenbaum serves as vice chair of the board of directors of Parent Heartwatch and also serves on the board of directors of the Dominic A. Murray 21 Memorial Foundation and as a board member of the Louis J. Ancampora Memorial Foundation. He is co-founding member of HeartScreen New York, a Long Island and Queens-based organization which performs free heart examination and screenings for students, which has now conducted more than 8,000 screenings to date. He is a certified CPR and AED instructor, having performed or assisted in performing training of more than 20,000 people. And as an attorney, he has spoken and written nationally about CPR and AED usage and protection from liability afforded by state and national Good Samaritan laws. He has assisted in redrafting the Good Samaritan Law in the state of New Mexico and was a contributing author of the Dominic Murray Sudden Cardiac Arrest Prevention Act. Steve is a grateful survivor of sudden cardiac arrest, which occurred on May 6, 2009. He and his wife Sandy are the very proud parents of 3 children and grandparents of 6 grandchildren. Thank you so much, Steve. We are so honored to have you joining us today to present on this very important topic.
Well, thank you so much for that introduction, Gina. I want to thank Joe Farrell, who has become my heart brother and one of my dearest friends for this opportunity. And I also want to thank Gina for the beautiful working relationship that she has continued with Parent Heartwatch and the support of Parent Heartwatch, where we are primarily focused with the elimination of preventable sudden cardiac death in the youth. So we share missions. AEDs are equally important to all of these goals of ours. And what I plan to give you today, or I hope to at least, is an understanding of Good Samaritan legislation for you to take back to your AED CPR students and to your community, and to understand that this is a very powerful weapon we have in trying to dispel public misinformation that the acquisition of an AED will incur liability. And it's actually quite the opposite, that Good Samaritan protection against litigation does not commence until there's an AED that's used. So that's going to be the purpose of this. In May, as Gina told you, I will be 17 years old, so I'm very young at heart. Even though my picture is a little outdated, I'm still only 17 years of age. And it's absolutely my pleasure to talk about this today. So I'm going to go through what the sudden cardiac arrest is, what our goals of sudden cardiac arrest, Good Samaritan laws are around the country, and then we'll go and take a deeper dive. Okay, next, please, Gina. So I think this is a very terrific statement about what our neighbors to the north are doing. And they are addressing the responsibility of citizens when they encounter someone who's in cardiac arrest. And you see that statement by Dr. Christian Valancourt. That statement is more than 10 years old. And unfortunately, despite all of our best efforts to increase saves from sudden cardiac arrest, still remains sadly at around 10% or so nationally. So our goal here is to help move that needle. And our neighbors to the north, as you see at the bottom, that in Canada, they have, Good Samaritan laws as well. All right, next, please, Gina. Okay, so what are our goals here? Our goals, first and foremost, are to save lives. Secondly, public awareness. Those of you who teach CPR are painfully aware that public awareness is minimal about what a sudden cardiac arrest is, what it looks like, what to do. And this goes along with public education. So, in your CPR classes and in your daily life, I hope to help give you a little bit more information to help spread public awareness and public education. The links in the chain of survival are critical. People have to be made to understand that unless the public knows how to do recognize CPR, know how to do um, chest compressions, and know how to use an AED and the immediate availability of an AED, that the save rate is just not going to change. So I hope to give you some information to do this, and at the end, save lives. You can go next one, Gina. Okay, this is just a quick chart. Really don't need to take a good look at it, but those of us involved in the sudden cardiac arrest community know what a serious problem this is, and that about 350,000 Americans are dying from sudden cardiac arrest every year. And being on the board of directors of Parent Heart, which I'm particularly sensitive to the numbers as they affect kids, 21 and under, I believe, or 22 and under. There are current statistics would say 23,000 kids a year are dying from sudden cardiac arrest. So whenever someone says sudden cardiac arrest in children is rare, the answer is it's not. It's number one cause of death among college athletes and down. So we have to keep into account our kids as well as we continue to educate and raise awareness. Okay, next, please. Okay, so as again, I just pulled the statistics just from 2010, and there were only, in my opinion, 36 states that had a law encouraging CPR training in schools. That number has risen into the 40s, but in this day and age, believe it or not, there are still states that do not mandate CPR training as a condition to graduation or to getting a driving license. And as we all know, the secret to saving lives is having people out there who know what a sudden cardiac arrest is and what to do. And Gina's predecessor and Mary and the executive director of Parent Heart Watch, Martha Lopez Anderson, have conducted a very, very strong campaign in my mind called Call, Push, Shock. And it really is as simple as that. And we use that in all of our training classes so that our students can go out and tell their students and the public. It's as simple as call, push, shocks. And we can add millions and millions of trained rescuers to the population by very simply just requiring CPR and AED training as part of the high school curricula. I can't think of one thing I remember from my high school days other than it was a fun time. But if I would have learned CPR or how to use an AED, I think that's the one thing I would have retained as of this time. And as I think that would apply to most people. Okay, next one, please, Gina. Okay, so we know the statistics. This is just a brief overview of what the statistics are. We all know all of this. The effective bystander CPR, it works. It increases the save rate. It increases the save rate for people without sustaining neurological dysfunction. Bystanders get involved, and we all know what this can do. So there are certain barriers, though, to bystander CPR, which we have to overcome in our training sessions and in our interaction with the public and with merchants, particularly stores and hotels and movie theaters and restaurants. You'd be shocked to know that most hotels don't have them. And when we do our research to try and find locations where we can hold our annual heart-to-heart meetings in January, it's shocking that a lot of we won't even go to a hotel if they don't have AEDs on the premises. So I encourage you to ask for AEDs. I know there are Marriott chains that have hotels, and they have pools and they have gyms and they have catering halls and outdoor activities and don't have AEDs on the premises. So please, in order to help us move the needle, um, be an advocate, and hopefully I'll keep giving you some more and more ammunition as we go on. Next, please. Okay, so these are the barriers to our goals. Um, Public apathy and lack of education. Lack of education meaning that people don't recognize what a sudden cardiac arrest looks like and why it's important to get to that person, get the ambulance on the way, but get to work on that person while the ambulance is coming. So that's just a lack of education. People are getting confused. They're getting scared because they just don't know what it looks like and how important it is for them to get involved right away. Again, the next one is fear of failure, bystander reluctance. I think the bystander reluctance is more fear of not knowing what to do or not getting involved in something with which they're not familiar. So that's our job to, teach them. Next is I can call 911. It's not my responsibility. Uh, just for a turn of words, that's one of the most irresponsible things I believe anyone could say. We're all here to help each other, and calling 911 is good, but it's just not enough. And you see the other ones. Um, the bottom two are the most important ones in my mind: fear of litigation and ignorance of Good Samaritan laws. So let's try and educate everybody here and send our ambassadors out in the world with a bunch of new information. Okay, next one, please. Okay, so every single state, to my knowledge, has passed legislation requiring Good Samaritan protection. The problem is there is no unified federal legislation, and there's great variability of Good Samaritan laws from state to state, and therefore there's some confusion, misunderstanding, and/or deterrence. There are some commonalities, but each state, as to who is protected, what the circumstances are under which protection is granted, those can vary from state to state. But as a general statement, I'm going to say that Good Samaritan legislation protection does not take place if you are the one who has caused the person to go into the cardiac arrest. In other words, if you run somebody over and they go into cardiac arrest, by all means, we want you to try and help them. But you do not receive Good Samaritan protection because you caused the incident. And very frankly, any injury or death that that person might have is going to be from the automobile accident, really not from anything you try to do. So that's why it doesn't extend to that. Secondly, you would have to have caused or contributed to that person's death to be liable. And I don't know how you can cause or contribute to injury or death to someone who's in cardiac arrest because we all know that they already clinically dead. So we really cannot cause any harm or injury to them. And thirdly, and these are the commonalities, and the third commonality is that I'm fairly sure this is the law in every state. Um, in order to be held liable or to not have Good Samaritan protection, you would have to be grossly negligent. And under the law, gross negligence means that you act in conscious disregard for the safety of another person with a clear understanding that harm is likely to result. And I don't see how that can possibly be applicable if we are trying to help somebody to be grossly negligent. And when people ask me for an example of what gross negligence is, I'll give you the one I learned in law school. Someone drives 90 miles an hour through Times Square in New York on New Year's Eve. Okay, that person is being grossly negligent because that person is acting with conscious disregard for the safety of others with a clear understanding that harm is likely to result. So those are mostly the commonalities, but we'll get into them as we move along. Okay, next one, please. Okay, so why do I talk about um, disparities between states and things like that? The role of the law is just as I stated on this page. I'm not going to read them all, but the role of the law generally is so people understand or should understand what their rights and obligations are in being a citizen of their respective states. So the role of the law is to establish reliable and enforceable guidelines to govern people's conduct. That applies to civil law as well as criminal law, obviously. And civil law comes about in two or three different ways. Civil law is created by exact statutes, which are enacted by our legislatures, or they evolve from what's called common law, which is case law decision, which serves as precedent based upon prior cases that have been decided with similar issues. So that's how civil laws are made. And a Good Samaritan law is purely statutory law, purely. So it has to be interpreted strictly as written. And we'll go through some of them in a little while. But if you want to look for the Good Samaritan law in your state, you can just Google it. And even though there's a lot of legal gobbledygook in there, I think you'll get the message. But I'm going to try and help you generally get the message today. Okay, so let's go to the next slide. So, what is the Good Samaritan law? Okay, let's start with um, in most states, I think only in Minnesota I've found so far, but almost universally in this country, except for those few states, a person who comes upon an incompetent person who is unable to give their consent on the street and volunteers to has no obligation, excuse me, under the law, except I think in Minnesota and maybe one or two other states, to come to the aid of that person. Okay, I know here in my home state of New York, um, I know there's a misconception about the amount of crime here. It really isn't true, but if you come across someone who's been mugged and down on the ground and injured, you do not have a legal obligation to come to the aid of that person. Okay. If that person is incapable of giving consent because they're unconscious, or in the case of a sudden cardiac arrest survivor, unresponsive and not breathing, we have their implied consent to do that, to come to their aid, but we don't have to. Okay. So, what's the Good Samaritan rule for? The Good Samaritan rule is to encourage lay rescuers, people on the street like you and I, to come to the aid of an injured or ill person without expectation of compensation from being liable for negligence, as long as the volunteer aid giver acts with reasonable care and without gross negligence. Okay, so I want to make sure, number one, we have no legal obligation to do it, but the Good Samaritan law is placed so that it encourages people to come to the aid of others on the street without fear of liability or litigation. Okay, next, Gina, please. Okay, so what's a Good Samaritan? Sometimes people learn better from pictures. Here, this says, "Thank you. My insurance doesn't include roadside service." So we have a Good Samaritan here. Those of us who learn by visualizing see that this person came to the aid of the gentleman on the ground. I don't think he caused everything that happened here, and he's doing this voluntarily. This is what a Good Samaritan would be. All right, so let's move on away from the legal mumbo jumbo and get back to it now. Okay, so what's the purpose of the Good Samaritan law? To remove fear of bystanders from helping someone for fear of being sued for injury or death. Again, I repeat, you cannot, in my opinion, cause unintentional injury or death to a cardiac arrest victim because they are clinically dead, right? And we all know the signs of that: unresponsive and not breathing. So the law encourages people to come to the aid of others. And once again, there's no legal requirement to do it, but this is your protection for being a good Samaritan. I'm going to tell you right now, my cardiac arrest happened in 2009. That's when I started becoming aware of the law on this issue. And I can tell you with very high degree of certainty, I've never seen a case nationally where a good Samaritan on the street has been held liable for causing injury or death to someone else. Okay, it's just, in my opinion, almost impossible to be held responsible for that. And so far, I haven't seen it in the close to 17 years that I've been involved in this. Okay, move on, please, Gina. Okay, so what does the Good Samaritan do? How does it defend you? Okay, number one, the care was performed voluntarily and as the result of emergency without expectation of compensation. I should add in there that the person is incapable of giving their consent to you rendering care to them. So that gives you the authority to go up and help them. Okay. Again, the initial emergency was not caused by the person causing the injury, and the care was not given in a grossly negligent or reckless manner. Okay. That is universal to just about universal as to what Good Samaritan protection is. That kind of sums it up nicely. Okay, and I will tell you this: those people out there who are afraid of acquiring AEDs have to understand that you do not get the protection of the law unless you have an AED. Okay, the Good Samaritan defense does not kick in unless an AED is there. Okay, and really whether you use it or not, and I'll get into that a little bit later. Okay, move on, please. Okay, so the federal government um, sets um, immunity from liability for harm resulting from AED used by lay responders in out of hospital settings. So anywhere you go in the country, and I know that each state has its own, but Good Samaritan legislation, but the federal government has enacted one as well. So we are fully protected wherever we go in our country. Next, please. Okay. Um, some states, this is where we get some variance between the states. Even though all the states have Good Samaritan laws, uh, some of them require AED training in order to invoke Good Samaritan immunity. Those states are few and far between, but they're still out there. And I urge you to, or encourage you, to check your own state Good Samaritan laws if you have any further interest in that. Next is medical oversight for what's called public access defibrillators, meaning that a doctor has to sign on and be available for consultation and maintenance issues, all that stuff. And we need AED training and maintenance on these defibrillators and also post event reporting. Again, these vary state by state. So if you're a particular state, if you're interested, just look it up. Okay, next one, please. Okay, so there are some states which do have AED mandates. You can see which ones they are. I just pulled these out randomly to show you the types of businesses or buildings where AEDs are required to be by statutory law. So there is no general requirement under the common law, meaning state, court decisions, that buildings or locations have to have AEDs, and it's only by legislative law where buildings have to have AEDs. If it's not specifically mandated by written state law, then an AED is not required to be at that particular location. Okay, but you see here, dental offices, public schools, state buildings, health clubs, and new buildings under construction or renovation. So, this has changed and it's constantly changing. But this is an example of where AEDs are required to be. Next one, Gina. And this is some places where AEDs are additionally required. Fortunately, in public schools, that has expanded dramatically. The first state in the country to require AEDs in public schools is here in New York. Those of you who may be familiar with Louis Acampora and Karen Acampora would know that in 2000, Louis was hit in the chest with a lacrosse ball at a lacrosse game and at school, and 14 years old in his first lacrosse game in front of his parents, and he was hit in the middle of the chest. And just like Damar Hamlin, he went into commotio cordis. He collapsed on the field, and there was no AED there, and he died. And much to the Akampora's credit, they had become incredible advocates. And by 2002, they had the first law in the country passed requiring AEDs in public schools, all public schools in the state of New York. And to this day, I believe there are, when I last heard, 126 documented saves in schools. So you have to appreciate that when there are saves in schools, it's not just school children. It's custodians, it's people who work in the office, it's teachers, it's visitors. So these are very important. This has expanded across the country, but there are still some states where it's not required. Next, you see AEDs in selected health clubs. In my mind, they should be in every single health club. But you're going to see later on that it unfortunately may not even matter as a result of the law. But in these particular states, AEDs are mandated to be placed, and in public buildings, Arizona, etc. Also, I should also add, in my opinion, there should be legislation passed where legislation has previously been passed requiring AEDs to be placed as to where they should be placed. They should be placed in a public location, in a clear box identifying it with a three-dimensional sign on top, without warning words that this should be used only by trained responders. We had a case right here in New York where a court officer went down. The AED was kept in a locked box. So this isn't the courthouse where I go to work. The AED was kept in a locked box, filing cabinet, with a bar going through the handles with a combination lock on it. And the court officer, who was the only one trained in CPR, had to leave the victim. No one started CPR. He had to go find the box, and he had to use the combination lock and open up the lock and then get back to the patient. I happened upon the scene at that time, and I did the chest compressions, but it was just too late, and he died. And then spoke to the administrative judge, and now the AED is in the proper place. So people may be proud that they have an AED, but it may be in a locked drawer or where nobody knows about it. So when you go in and advocate for the placement of AEDs, make sure that they are publicly available and prominently displayed with three-dimensional signings. Okay, next, please.
Where's the sandstone one?
Okay, so one of the requirements in many states, and again, it depends on your states, require the registration of AEDs with local authorities, and that includes the 911 responders, so that these days AEDs are changing, and sometimes AEDs can be alerted as to the existence. Privately owned AEDs can be notified of the existence of an event, and someone with an AED can respond a lot quicker than 911 can. But again, this process is different in each state. And again, sometimes the process is cumbersome. There's a lot of paperwork to be involved, and that also needs to be cleaned up because that can become a deterrent. We all know we try to log onto something and or call somebody, and when we get 14 answering machines, or we try to log on and we have to hit 8 buttons to get where we're going. So this all has to be unified and simplified. The registration I'm talking about. All right, next, please. Okay, so these are some current problems. Some states require AEDs to only be used by trained operators, or prohibited from use by untrained operators, however you want to say it. And we all know how simple AEDs are to use. And I think this is an obstacle in the law which needs to be addressed. Um, so it shouldn't only be trained responders who can use AEDs. It should be everybody. Some states only have Good Samaritan laws protecting trained responders, and also require physician supervision over AED owners, which is also cumbersome. We need to simplify this and make it as easy as possible. Okay, next, please. Okay, so now we're going to talk about Good Samaritan, and we need to get a little involved into legalese over here so that we can understand the effect and force of the Good Samaritan law. So I used the word gross negligence earlier, but that is a much higher standard of failure to comply with what's reasonable than is negligence. Negligence is the existence of a duty or an obligation recognized by law. So, as I told you, there is no responsibility under most of the states in this country to come to the aid of another. And simple negligence is failure to conform to reasonable care under the circumstances. And if you look at the last one, the negligence must be a proximate, substantial contributing factor to an injury or death. And I don't know how that's possible under the circumstances. Okay, let's go to the next one. We're moving along a little bit. Gross negligence, I mentioned earlier what it was. And if you do what you were taught to do in the CPR course, you will not be deemed to have been grossly negligent if your attempt fails. So don't worry about that at all. Do the best you can under the circumstances and you're protected. Okay, next. This is just a Good Samaritan Act. Just to give you an example of what it actually looked like. And I highlighted in yellow, who's protected and who's not protected, um, and the circumstances under which Good Samaritan law applies. So you'll find this in just about in every state's law. Here in New York, it's called the public health law. It's probably called something else in each individual state. Go to the next one, please. Okay. So this is one of the problems in New York with the public health law about AED training. So we want to try and get rid of that as a requirement for Good Samaritan protection, wherever it still may exist. This may have been changed recently, by the way. So Florida also, that's what the Florida statute looks like. There's really no need to read it. I'm just using this as examples of what the law looks like in each case. But I hope to have given you the overall concept so that you can understand this, not being legally trained. Okay, so let's go to the next one. This is a case in Florida, um, and there was no AED on the premises. There was no Florida law requiring AEDs in gyms. There was no CPR performed. Keep going, please. And the Florida court ruled, and this is very important, owner must take only minimal steps to safeguard a patron, but no duty to perform medical rescue procedures. Okay, if they summon medical help within a reasonable time, they will not be held liable. Okay, the same thing goes for CPR and the Heimlich maneuver. All right, so what this court is telling you is that the owner of a premises only has to take minimal steps to safeguard a patron, but there is no duty to perform medical rescue procedures. And as long as they call 911, they're fine. There's no liability that attaches there. Okay, so move on, please. Another case in New Jersey. The owner of a Ritz-Carlton, you'll see, which is a very high-end chain hotel, did not have an AED on its premises. There was a Good Samaritan Act in effect, and the court held that the owner's duty of care to the patron was discharged when medical help was called. Okay, and there was no AED on the premises. So this again is reinforcing that the owner of a building, just by acquiring an AED, or by not acquiring one, or even acquiring one, does not have a legal obligation to use it. Okay, and simply calling 911 is satisfactory to the court. All right, go on, please. Here's the Good Samaritan Act in Texas. And Texas is a little broader. You'll see in the bottom that Good Samaritan protection applies without regard to whether the care is provided for or an expectation of remuneration. So Texas is even extending that protection even further. And I believe there are a couple of other states that have done that as well. But Texas is very responsible in this regard. Next one, please. California CPR, we don't need to go through that. And again, I just wanted to provide it, but I do want to talk about some cases so you understand how much protection there is. Go on next, please. Um, again, this is just a restatement of what I told you, but a physician is even protected from liability if you look at Section D at the top. So it extends in California more than it does here in New York. Okay, next, please. Um, Michigan is showing some responsibility and is giving immunity from liability for school employees using an AED in their employment. So that is a good advancement. Okay, next, please. Okay, so there's a case here in New York which is very, very disturbing. There's a parallel case. So this one is DiGiulio. There's a parallel case called Miglino, Miglino. Here in New York, AEDs at that time were required to be present in health clubs with more than 500 members. I think that's now been lowered to 300 members or something like that. But in any event, under this scenario, Mr. DiGiulio was within a facility where an AED was mandated by law. Okay, CPR was started, but no AED was used. Okay, go next, please. Um, in this poor, unfortunate case, the reason why the AED was not used is because the cabinet had a lock on it, and the employee there did not have a key, and believed that the cabinet was locked. So he was spent time searching for the key, and the cabinet was never locked, and this poor gentleman passed away. So here we have a situation where law requires an AED present. The staff does not use it. And the issue now becomes, is there under the law a legal obligation to use an AED in those circumstances where the law requires its presence? Let's see what the court did. Okay, believe it or not, the court held that no viable cause of action exists, that the risk of cardiac failure is inherent when participating in that activity. In other words, blame the victim for going to a gym, and that the club fulfilled its duty simply by calling 911, and that the club was not under any legal duty to use the AED despite the law requiring its presence. So, for those of you who've asked questions about whether liability is incurred by the mere acquisition of an AED, the answer is no. And at least in my state, and I believe this answer would be the same in most states. The courts are not finding that there is a legal duty to use the AED in cases where the law requires its presence. To me, that's lunacy, but that's the way the law is, and that's the extent to which Good Samaritan protection will extend to people who acquires AEDs by holding that acquiring them does not create liability if they're not used. There's no legal duty to use it. You could simply call 911. All right, next, please. Okay, so here in New York, um, you can see what the court held. The court didn't construe the laws imposing liability on a health club, but whose employee exercised poor judgment in attempting to access it or use it. Well, this was more than poor judgment. And in my mind, it was gross negligence. But the court refused to hold that. And that shows you the protection, that shows you the truth about the misconception that acquiring an AED incurs liability or subjects someone to liability. Next, please. Okay. All right, we can skip this. But the thing, just go back 1 second. Once again, they misrepresented what had occurred here. They called it a heart attack, and those of us in this world know the full difference and the importance that it makes. And even the highest court in New York State was not informed properly as to what happened. All right, let's go to the next one. Same thing happened to this gentleman, Mr. Medlino. He was in the gym. No AED. The AED was present, was not used. Go next, please. Okay. This is the um, ruling. Uh, I'm sorry. This is the dissent, which is. Uh, I'm sorry. I withdraw that. There's an affirmative duty for them to have gyms to have an AED and an employer trained to use them, and it's illogical in New York State to conclude that no duty to use it exists, and that needs to be changed. How we do it legislatively is the only way. Keep going. Um, Good Samaritan's law still provides protection to those using AEDs unless there's gross negligence. So that still hasn't changed by those decisions. All right, go ahead. You can go ahead. Next one, we're running a little late. Okay, so the standard of care is AEDs are becoming an unofficial standard of care, but until they are the standard of care legislatively, that is not going to happen. Go next, please. Okay, and go to the next one. I just want to say this is more language from the courts, which says that the words in the law in the Good Samaritan are to protect health clubs and their employees for the risk of liability with respect to AEDs. So that obviously extends much more to those store owners, merchants who are not under a legal obligation to have it. Okay, next, please. Um, the court essentially said that legislative enactment creating liability when none previously existed must be strictly construed. And at the end of the day, they held that if the legislature wanted to impose a duty on gyms to use AEDs, they would have to pass specific legislation stating that. And I have not seen that anywhere in the country. All right, go next, please. Go next, please. Okay, so this is the dissent. Um, at the bottom, the statute should be interpreted in a way that is consistent with its spirit and benevolent aim. So we have a lot of work to do there. Okay, next, please. Um, and the chief judge, that's the dissent. I cannot agree with interpretation that is so plainly contrary to accomplishing the goal of the legislation. So the chief judge commented on that, but still nothing has changed here in New York State. We'll go next, please. Okay. So, if you look at the bottom, what are we to do now? Let people, gym owners and other locations where AEDs are required by law, even if not mandated, their protection by Good Samaritan law when AEDs are used, and there is no duty to even use it, provided they call 911. They've discharged their duty of care to their patrons according to the law. Next, please. Okay, so this is just gym owners. When I talk to people, store owners, I ask them, um, first of all, I ask them, if there's an AED here, who spends the most time in this location, and who's the person most likely to be saved, and that's you. And secondly, do you want your store to be seen in tomorrow's newspaper where someone was saved because the owner was responsible, or the place where someone died because the owner was unresponsible? I think we have to hit these merchants in their pockets where they will understand it. Okay, next, please. Okay, so I stand by this. This is cited by the Journal of the American Medical Association. You can cite this article published in February of 2006. This is current as of today. All right, so this has to be made known to the public. Next, please. You can go on past that one also. Go on. Okay. So, there are always multiple attempts at changing the federal law. It was changed in 2023 to try and, unify what Good Samaritan protection is, but it still hasn't quite gotten there. But there are attempts to do that, and we're behind some of those measures. Okay, next, please. Okay, so there will not be immunity unless the person is grossly negligent, and that you can take to the bank, and that the misconduct caused harm to somebody. So therefore, no liability. Next, employee has to be caused um, within the scope of employment. Um, it's inapplicable if it happens in a hospital for the most part. There are one or two states in response to some of the questions I get, which actually do address that and do provide immunity inside of a hospital or a doctor's office. Okay, next, please. Okay, that's the most current HARTS Act on the federal level. And you can see the highlights of what that's doing. One of the most important things that we are doing in terms of schools through Parent Heart Watch is trying to get requirement of SERPs. We call them cardiac emergency response plans. So, and we're trying to get them to have CPR drills and AED drills along with their fire drills. 3,500 people a year die from fires. 350,000 die from cardiac arrest. So the numbers speak for themselves. Next, please. Okay, we can move on. All right, so cases have happened all over the country, and none of these cases have succeeded because the court held in each case there was not a duty to use the AED imposed by law. So without that duty, uh, the standard of care becomes just to act reasonably, and the courts have interpreted that as calling 911. But this is happening all over the country, as you can see. All right, next, please. All right, so can you make a difference? Yes, you can. And here's a case where someone died at a pool. I don't know what the outcome of this case was, but a city was sued because a public pool owned by a city did not have an AED. Go next, please, Gina. Okay. You can see this, and then I'll get to you about what advocacy can do. Go to the next one, please. Here it is. Okay. So this case is right here in New York. Someone approached a man tried to donate an AED to a public park in the town of Smithtown, and was turned down by the lawyer of the town because the lawyer said that they don't want to incur liability. That guy called Karen Akampora, and Karen Akampora called me. I spoke with the gentleman who wanted to place the defibrillator, and I heard what the town sent to him. I called the town attorney up and I educated him. And 3 days later, in our local newspaper, it says defibrillator at park. Okay, and the reason given is not that someone informed them better, but that they were more concerned about the safety of the town residents. So that just goes to show you that advocacy can work. Okay, next, please. Okay, and that's what a bad Samaritan does. Bad Samaritan intentionally acts recklessly, causing harm to somebody. So again, those of you who learn by pictures, that's a good picture to show you to reinforce what gross negligence is. Is this gentleman subject to Good Samaritan protection? No. Okay, Gina, go to the questions, please. Okay. So the first question that was submitted was a question about cover usage of privately owned AEDs. And Gina is going to, have these slides so you can have, and thank you to everyone who submitted these questions. Um, and the answer generally, if you have an AED in your home, you don't have a legal obligation to use it. Simply calling 911 seems to be all that the law requires. Okay, if you do have it and you use it, you'll generally have Good Samaritan protection from liability. So, of course, I recommend having it at home. I have two at home, and I recommend that everyone should have one. But acquiring one does not subject you to liability. There's no legal duty to use it. And if you use it, Good Samaritan protection will protect you from liability. So either way, you are safe. So please um, acquire AEDs in the home. I think we know 70 to 80% of AEDs occur in the place of business or at home. So a good idea to have one there. Okay, next one, please. Please cover usage of AEDs. This happened in New York. New York does not specifically require doctors, although interestingly, it does require dentists to have AEDs in their offices. So many doctors choose to have them as a matter of best practices and responsibility, or to actually lower their insurance premiums. But they're not legally compelled to do so. I believe from the case law here in New York that I have seen that even if a doctor does not have one, he or she is not liable. And if they do have one, there is no legal duty to use it. Just call 911 seems to be sufficient. And if they do use it, they will incur Good Samaritan protection. So the safest thing to do is to have the AED and use it, and then you are guaranteed Good Samaritan protection. Okay, but I put a little more information in there. Next, are organizations, companies liable if they don't have an AED on site? Is it reasonable to not get one because they may be liable? As I said, there is no legal requirement to have an AED in any particular location unless specifically enacted by statute in that state. And again, there does not appear to be a legal duty to use one under the cases I've given you. Certainly, if there's no legal obligation to use one where they're required by law, I don't see a situation where they can be legally liable for not having one on the premises. Secondly, there does not seem to be a duty on them to use it either. So um, I believe that there is no logical reason to not have an AED on site. They do not incur liability. Okay, the next one. Let me just briefly throw this into everybody. I am only licensed to practice law in New York State, so I can only give legal advice here in New York State. So on the questions about out-of-state issues, I'm just giving you my interpretation of the statutes in those cases. So please understand that. Okay, so let's move on. What are the Good Samaritan laws in Georgia? And Georgia again talks about good faith, um, and it says it allows any person trained or untrained to use an AED, and the person has to act gratuitously and in good faith uses an AED, and there's protection unless they are grossly negligent. And this also applies to people who have an AED on their premises. So they specifically give Good Samaritan protection there in Georgia, and to owners of vehicles like a bus or a plane that carry an AED. And a physician is also protected from liability. EMS is protected from liability as long as the device is maintained accordingly. And bystanders are protected. So Georgia has a very good and very robust Good Samaritan law. I salute them on that. Okay, next, please. Texas also, I said earlier, has very robust Good Samaritan laws. Again, a person can only be liable for gross negligent. A physician has immunity from liability. Now, when I talk about immunity from liability, I want to make something very clear. This does not mean that some rogue lawyer can't go around and drum up lawsuits for these things. What it does mean is that those lawsuits are subject to being dismissed legally by a court as not having any merit under the law without going through a trial and all that. So when I say immunity, I mean ultimate immunity. I don't mean protection from being sued. I mean protection from liability. So make sure you understand that difference. Anyway, Texas at the end you can see makes it very difficult for someone trying to save a life with an A. It says within AED. I meant to say with an AED, even in a professional setting, unless the provider acts with gross negligence. So that gross negligence is a universal theme in determining whether or not Good Samaritan protection exists. And again, I don't think under the circumstances where you try to rescue someone that you could possibly be grossly negligent. Okay, next. I'm sorry if I'm speaking a little quickly. I'm just keeping an eye on the time. Um, do laws apply to EMS personnel acting in good faith? In Iowa, it looks like. So Iowa, I reviewed the Good Samaritan Law, and it says it's intended for emergencies occurring outside of a medical facility. So EMS, I'm assuming this means out of the facility. So they are held to the standard of care of negligence, meaning do they act reasonably under the circumstances rather than the protection under Good Samaritan law, were they grossly negligent? So an EMS person, as long as they act as other EMS responders would act, as long as they do what the standard of care is, or they um, do something or they not do something that another reasonable provider would do, they are protected from liability. But my interpretation of the statute after reading it is contained fully in paragraph 6. Okay, next one. Illinois, again, I checked the law out. The Good Samaritan law does apply to doctors as long as emergency care is provided without a fee. So, an example is someone in a waiting room, has a cardiac arrest. The doctor runs out and tries to save the person. There's Good Samaritan protection over there. All right. So, I thought that was, very important. Again, the commonality is person acting in good faith without a fee, and the person is not um, acting grossly negligent. There are requirements for AED acquirers, and that's pretty much universal. They must maintain it and test the device in accordance with manufacturer's guidelines and notify the local 911 system of the AED's existence. But again, the bottom line standard is whether or not there's gross negligence. Okay, next. North Carolina can delay a responder to provide care without consent if they believe the person is in an altered mental status. Okay, so um, I read North Carolina's law, and my interpretation of it is pursuant to North Carolina, consent is implied if a person is unable to provide it due to their physical or mental condition and immediate treatment is necessary, but it appears that that only applies to medical providers such as EMS doctors or nurses. Without specific language, I'm not convinced that someone in an altered mental status, if you render treatment to them, you're protected under the Good Samaritan law because they may be liable to give consent. A prerequisite to having Good Samaritan protection is that the victim be unconscious and unresponsive and incapable of giving consent. So I don't think that the law wants us as lay responders to make that determination for someone who's in an altered mental status as opposed to a full cardiac arrest where they're unresponsive completely. So that's my interpretation of the North Carolina law. All right, so that concludes the presentation. I'm sorry I ran through it quickly.
Oh,
We have a, oh, there's
there's
one
one
more.
more.
I'm sorry.
Sorry.
Okay, is that a new one? Oh, I responded. Okay.
Yes.
So in Washington, is there any decrease in liability for businesses that have an AED trained staff and response plan? Okay, so I started off by saying I could not find any law in Washington which required a business, a private business, to have an AED, but it seems like high risk environments are required to have an AED. And at the end, it says any person or entity that acquires or uses an AED in an emergency is generally immune from liability for personal injury resulting from the use of the device, provided they aren't acting with gross negligence. So there's the commonality. So again, in a state where they are required in a certain location, there's no legal responsibility to use an AED unless it's legislatively enacted, which it doesn't appear to be. And as long as you do not act with gross negligence, you are protected. So, in my mind, the key element in Good Samaritan protection is gross negligence. Okay. Are you acting in conscious disregard for the safety of another individual with a clear understanding that harm is likely to occur? And the answer is no, 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 no. All right. And that's the information I want you to take with you from here. Okay. That you cannot hurt a dead person, you cannot injure a dead person. And by trying to help someone, you have not in any remotely way acted with gross negligence, and you have full protection of Good Samaritan legislation. So my advice is to go out there, use it as a sword. Here, you're protected. Do it. Okay. And whether the law requires you to have it or not, you do not incur liability just by having it. And if you have it, there's no legal responsibility to use it. You can just call 911, but make sure you do that at the very least. Okay. So this is meant to, save lives. Um, I remain available for any further questions. If there's any now, which I can understand, which are not state specific, I'll be glad to do that. I really would like to thank you for the opportunity to do this. This has been a tremendous outlet to me in my recovery and in my attempt to justify my good fortune in in being saved, as so many of you are doing in your own world. So I applaud all of you for all the work that we're doing together.
Thank you so much, Steve. That was wonderful and so much helpful information. So thank you for sharing your time and your expertise with us today. Um, for those of you, so the way that we did the questions was to have folks pre-submit their questions at registration so that Steve could have time to research the specific state nuances. I put my email address in the chat, so if you have any follow-up questions, I can collect them, get them to Steve, and then I'll follow up with his responses. So he's generously offered us to follow up as well. So please do feel welcome to connect with any follow-up questions as well. Steve, you're getting accolades in the chat here for all the great information. Just a couple of things as we close out, and I realize we're a little over time, so thank you for staying with us. We have a lot of upcoming webinars and virtual events, so please take a look at the calendar. There's the QR code on the bottom of the left-hand side there with lots of different more detailed information and registration links for each of these events. So I hope that you'll continue to join us. We have another webinar later this week on Friday focused on survivorship and rebuilding routine after sudden cardiac arrest. So that is what is next on our schedule, but please do join us for one or more of the sessions, and there's some QR codes for other ways to get connected and stay in touch. But thank you everybody again for your time and joining us today, and huge thanks to Steve for joining us and sharing this great information with us. Thanks everybody. Have a great afternoon and take
Thank you,
care.
Steve.
Joe, you're very welcome. I see James is asking me a question.
Oh,
Does he want to ask me a question?
let's take a look. Is there liability if an AED is used on an infant with when the manufacturer does not recommend it for infants? Do
Okay,
you want to comment on that
I
one?
can answer that. Those of us who are CPR and AED instructors know that if there are no infant pads available, the standard of care is to use adult pads. Just use them front and back, not two on the chest, because we can't allow them to touch. They can only be used front and back, and you may cause damage, but that is the standard of care. And that is the only way to get the child out of cardiac arrest and hopefully save them. So we want to obviously try and make sure there's child and infant pads available. But if they're not, we are taught to teach that it is the standard of care is to use adult pads front and back, and that is not grossly negligent. That is the standard of care.
Okay, thank you.
Steve, could I just make a quick comment?
Sure.
You know, I know there's a number of survivors and co-survivors on this call, and I think one of the themes that Steve was talking about is advocacy and education and awareness. And I think that we're the best representatives as survivors and co-survivors in our local communities to get involved as if you so desire, because we can make a really big difference on the grassroots level to make changes in various laws and to get AEDs. And it's just a comment to just trying to stimulate people to, you know, be advocates if you're up to it. It really makes a difference because every life is precious, right? We're all here
Yep.
because someone stepped up to save our lives. Thank you.
Thank you, Joe. And just to comment on that, I put two links in the chat. There's the Casa Hearts website, which is our Cardiac Arrest Survivor Alliance. So that's for survivors, co-survivors, advocates, and lay responders. So if you are not yet connected into that community, please join us. And then I also put our link in for our Heart Champion program. So that's our volunteer advocacy program. If you are looking to get more involved, we have resources and tools and lots of training, webinars, and opportunities. So would definitely encourage you to join in with that too.
There was one more question that just came up.
Yes, I think it's a follow-up to the other question. Some AED manufacturers, such as LifePak CR2, specifically say it is not for use on infants, even though there is a child setting on the CR2.
Okay, infants is different than children. Okay, if that's the distinction in the CPR world, infants are 1 year and under, children are 1 to 8. I'm talking primarily about children. Um, yeah, children, age 1 to 8. I'm not talking about infants. Um, and this is what I'm AHA certified instructor, and this is what we are taught is the standard of care. So that's all I can tell you. What I've been taught and what I've been authorized to read to teach. But I don't know if the distinction, James, is that this is an infant, meaning someone 1 year and under, or um, children 1 to 8. But what I would do if that's the machine that you have, number one, make sure you have child pads. And number two, contact the manufacturer and ask them the question, are they distinguishing between infants and children 1 to 8 and infants 1 year and under? I would contact the manufacturer for that.
Thank you. Leslie, did you have a question?
Sorry about that.
Hello, Leslie.
Hi, my name is Leslie. I'm with the Compressive Shock Foundation. I just had a question in regards to the liability in general. This could be generalized for New York State as well as one of the states we work with. I'm actually located in New Jersey. When it comes to speaking with larger organizations, how can we effectively approach businesses or their legal teams when addressing liability concerns related to placing the AEDs in public places.
Okay, I think the surest entree, and this is what I do, is there are two foundations here on Long Island where mothers lost their children. And when I want to, and most of the CPR training that I do is through those. And when I want to get into an organization, the easiest way I found to do it is to offer a highly discounted CPR training class for their executive level people. Um, the classes that we do here are all volunteer. We don't charge. A minimum amount is charged to cover materials and things like that. But if you can get to the HR department and tell them that you want to spread the word about CPR and AEDs, we'd like to give you an offer to do a reduced cost or a free AED, a CPR training class and certification. Then you get their attention because they don't understand the importance of having AEDs until they understand what a sudden cardiac arrest is. And the only way to tell them what that is by a training class. So that's how I get into organizations.
Thank you.
Awesome. All right. Well, thank you again, everyone, for joining us. Thank you, Steve, for sharing your
Sure.
expertise with us. And feel free to connect offline for any other follow-up questions. But I wish you all a great afternoon. Thanks, everybody. Take care.
Okay. Bye.
Bye.